One of the most common mistakes that happens in an estate plan happens right after the signing of the document. Most people believe that once you sign your documents, you are done with your estate plan. However, that is the misconception. It's not true. Whatever you've put in writing, and if you've hired an attorney, you've invested your time and money to put these documents together, what is put into writing needs to be put into action. So, putting your signed documents into action involves safekeeping original documents, making sure there's a way that those documents will be accessible when something happens to you, establishing that emergency plan, and then also making sure that all of your assets agree with the plan. In Kansas, we're one of the states that still requires original documents to be producible by trustees, agents, and executors. So that does mean that if you are given your originals, you need to make sure that your loved ones, your trusted parties who are going to carry out your plan, will have access to those originals. After you pass, whoever you've named as a responsible party will have to go out where you keep your accounts and inheritance and wherever your assets are left. A bank, for example, has a right to ask for an original document. And if you've locked away your estate planning documents where this trustee or executor or agent can't get a hold of it, we run into a problem. Sometimes that problem needs to be resolved by a court process, petitioning a judge to either nullify the terms of the trust or redeclare it, going off of speculation or evidence that can be produced. So first thing you want to do is establish an emergency plan for your documents. The next thing you want to do is double check that your assets are actually in agreement with the plan that you've put together. Beneficiary designations on any account would supersede what an attorney would be preparing for you. If you wrote in your will saying that my spouse will get my house and all of my remaining property, but you had an account out there that listed your sibling as a beneficiary, in Kansas, that account would go to the named beneficiary, being your sibling, and not to your spouse, even though you spent a lot of money to put an estate plan together. If you have an attorney who's given you a cohesive plan and instructions about how to make those items agree and make sure that your beneficiaries are updated, that's a necessary step. Failure to take the step of making sure that all of your assets are in agreement and in alignment with the documents that you've signed is one of the more crucial steps. A good estate plan is about signing documents. It's about making sure that everything is aligned with your intentions. None of this should be taken as legal advice. You'll want a qualified lawyer to prepare an estate plan for you. I practice in probate and estate planning, and we do a lot of cleanup from self-help online wills or AI wills or trusts. There's a lot of traps for the unwary, so you do want to have an attorney help you through this process to help you avoid some of these common pitfalls. If you have questions about whether your plan is fully set up, that's something that we help with. Give us a call.